the Bharatiya Sakshya Adhiniyam or BSA for short. The core principles under the old Indian Evidence Act have remained. However, the new law brings in some changes that help modernize the system. So whilst the classic principles of burden of proof, admissibility of evidence, probative value and other core principles remain the same, there is a strong thrust on ensuring a proper framework for admissibility of electronic evidence. Under the new law, a clear legal matrix has been created for electronic and digital records to be treated as documentary evidence. This includes all forms of electronic communications and records such as emails, websites, voice, data, or any other message which is communicated through electronic form. This sets at rest debates and interpretations that have existed. Electronic and digital records are now clearly classified as primary evidence. This is also a recognition of the impact the digital revolution has had in modern times, wherein most of our lives are captured and processed on digital devices. The BSA therefore acknowledges this reality and brings electronic evidence under the ambit of primary evidence. Whilst the three new laws usher in an era of new reform, the last word has not been said yet. Indian justice delivery system requires overhaul, reform, and this must be made to bring speedier justice to the litigants who approach the courts in the hope of securing justice. These three legislations are a great step to shed the remnants of the colonial past, but one must also focus on the issues that plague the Indian judicial system, whether it is lack of infrastructure at the trial courts, it is a truncated number of judges in India, or the long wait for justice to be delivered.